Everyone for joining us at our very first webinar as Stratafin. Today, the topic that we're going to be discussing today is how to handle a non-paying owner in a sectional title scheme, which we have found is a very relevant topic. We've been seeing it on a lot of Facebook groups, and everyone we speak to just doesn't know what to do. So I wanted to introduce our speakers first. Our first up is Willie Roos. He is the CEO of Stratafin. Willie has practiced as a property attorney for over 20 years. He has been involved in sectional title management for over 8 years. Willie started Stratafin in 2014 with the goal of assisting bodies corporates with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. Willie has built up Stratafin from its inception to where it is today, with debtors under management of over 300 million rand. Stratafin have partnered with Merwe Capital, and the PRC has invested with a 45% ownership. Our second speaker today is Zerlinda van der Merwe, which I'm sure you all know her. She is the co-founder and director of TVDM Consultants. And from growing up in community schemes to obtaining her master's in the subject, Zerlinda has pursued her passions for the industry by being a managing agent and a specialist community schemes attorney. As trustee in both her professional and personal capacities and member of various types of community schemes, Zerlinda lives and breathes all aspects of the community schemes living. So I'm going to hand over to Willie now, and he is going to explain how we're going to do this today.
Thank you so much, Daniela, and thanks for everybody for joining in on our webinar, and we trust that we will give you guys some valuable information that you can use in your schemes, and there's also some stuff that we will be throughout the webinar will be giving you guys, and we trust that will assist you guys in respect of your schemes. So we're going to have a look why non-paying owners pose a threat or a problem to sectional title schemes as a whole. And we need to have a look at the result of the inability to pay levies and what that causes to a scheme. And the first thing that we see is that it causes the scheme not to be able to pay the day-to-day expenses of that scheme. For example, the council in respect of water, electricity, the cleaning, security, and all the other day-to-day running expenses in respect of the building. It also causes a problem in respect of maintenance. So no maintenance can take place. The 10-year maintenance plan cannot be put into operation as well, and as such the scheme then starts going backwards, and at the end of the day the building will become run down and dilapidated. If the financial statements of the body corporate also shows that a huge amount of money is owing to the scheme, the banks will also be slow in financing the sale of units in these buildings, and people won't be able to obtain bonds. That will then cause the property prices in that scheme to fall, and owners won't be able to get a purchase price or a selling price in respect of the unit which exceeds their bonds, and they will then be stuck in the scheme and not being able to sell their units. So that will then at the end cause a destruction of the scheme as a whole, and it will also destroy the owner's equity in respect of his or her property. We then see that once these units can't be sold and owners then just abandon them, that you get the hijacking of these buildings, you get people that move in mass into these buildings and then take over the building as a whole. Overcrowding occurs and it becomes a huge problem. This causes the destruction of the scheme as a whole, and it causes a destruction of owner equity as owners can't sell these units and can't realize any equity built up in the scheme. So we then are going to look at a couple of things that one can do to assist prior to the owners falling in arrears, and also what one can do after owners have fallen in arrears to determine or to make provision for non-paying owners. So before owners default, one can look at budgeting, you can look at credit policies, and you can look at the changing of management rules. And then after default has taken place, we're going to look at the community scheme ombud services, we're going to look at legal action and other alternatives and outsource alternatives. So I will be speaking about budgeting, credit policy. Zerlinda will speak about changing the management rules. She will speak about csos a bit. I will then have a chat about legal action again, the alternatives and outsource alternatives. Myself and Zerlinda will have a chat about that again and give our thoughts in respect of that. Okay, so let's start with budgeting. So I think one of the most important things that a body corporate needs to get right is to get their budgeting correctly. And you do that by the trustees actually looking at previous year's budgets, determine what was spent, determine what needs to be spent in the next year, determine the amount of increase in respect of these specific items, and then to budget that into a proper budget, which then goes out to the owners for their approval. So some stuff that we have picked up that are not being budgeted for is a provision for bad debt or a provision for write-off in the budget. Now I know that if I say a provision to write off, some people might say that it's not allowed. However, the Act does not at any stage prohibit the write-off of debt. And if one look at accounting principles, one will see that the impairment of debt is part of what accounting principles are, and body corporates need to make sure that they know how much they will be able to actually collect from a specific debtor or owner. We see in lots of these buildings where we involved that the outstanding levies exceed the value of the property. So one can never recover that. It is impossible to recover levies that exceed the value of a property because nobody will purchase a property and pay more to obtain the property than what the value of that property is. So it's not going to happen, and therefore a body corporate will have to make provision. What it does cause is that there will be a slight increase in the average levy that will be paid by owner, but at least the body corporate will have made provision and there will be money in the budget to do so. We see that a provision that would be reasonable would be something between 5 and 15% of the value of the levies, because that's the type of default that we see in schemes currently. Something else that is not budgeted for in lots of the schemes are legal fees. I think Zerlinda will also have a chat about legal fees and the changing of rules. I'm not sure if that is part of that, but legal fees can only be recovered as far as they are taxed or agreed as the current rules stand. And that means that what an attorney charges is more than what can be taxed. So it works similar to that of a pension medical aid, where a doctor charges one rate and the medical scheme pays a different rate, and you are liable for the balance between the two. Attorneys charge a certain rate, and you can recover the taxed fee, and there's a difference between the two, and the body corporate out of the general funds will have to pay that difference as the rules stand currently. So we see that a legal action through attorneys normally is charged around about 40,000 to 100,000, 120,000 sometimes, in respect of actions up to a sale and execution of the immovable property. We tax bills on a daily basis, and we tax normally from start of legal action to sale in execution about 20 to 25,000 rand in respect of that bill. So in any given bill, the body corporate will have to pay an additional 15,000 rand at the lowest, and sometimes 60, 70,000 rand will have to pay in, depending on what attorney is being used and at what scale and what the agreement in respect of payment is. So that can become a very costly exercise, and trustees can't just spend this money if they have not budgeted for this money, because the moment that they spend this money and it's not in the budget, then obviously they are exceeding their powers, but also something else is not going to be paid. So we also think that between 5 to 15% of your yearly budget should be sufficient to pay for these legal actions. The legal actions can also take a very long period of time, so that must also be taken into consideration when one budget. A legal action can take anything from 18 months, which is a fairly fast period of time to get to a sale in execution, up to 3 years. And we have seen legal actions taking up to 5 years. So a body corporate needs to know that once they go into this legal process, it can take up to 5 years for them to recover this money and recover the levies. And then obviously they will be liable for the payment of the difference between the legal fees. Okay, so what we've done is we have drafted a budget on an Excel tool, and we've built an Excel tool that has all the elements that a body corporate should take into consideration. It also then does the calculation in respect of all the different participation quotas and determines then what is payable by each owner. So we will give this away to participants. So we will send out an email with a link where you can then click on and get this budget, and hopefully that will be a very welcome tool that can be used by body corporates in respect of their budgeting. So it's important that one needs to get that budget in order, and I think that's the first step that body corporates need to do. The second step that we suggest is to get a credit policy in order. So what is a credit policy? A credit policy are guidelines in terms whereof the payments or guidelines to set the payment terms and to establish a clear course of action for late payments. So the policy will effectively outline the steps and the procedures used to deal with defaulting owners. So I've drafted a credit policy, which we will also make available to participants of this webinar, where we deal with different aspects in respect of the credit policy. So we're dealing with payment, when is payment due, we're dealing with interest, so interest resolutions by trustees that can change from time to time, because interest can only be charged once that interest resolution is in place. That happens on a yearly basis by the trustees. We deal with penalties. Now, you guys are aware that you can't put penalties onto a debtor or an owner's account. You can only do so once it is included in the rules. And those rules have gone through the process, and Zerlinda will also have a discussion, I would believe, in respect of how that process is put in place to change rules and to make provision for penalties and to then legally charge those penalties. I'm also dealing in the credit policy with the letter of demand when that should happen. We believe that the quicker one takes action in respect of legal action or action, the better it is. So in terms of this credit policy that we've drafted, the action starts on day 7. Levies are payable normally on the first day of the month. And on day 7, after levies have not been paid, we believe action should be taken, and the credit policy deals with all of that. And then also the letter of demand. Letter of demand is given 14 days after that, legal action should be instituted. So that means that about after 30 days to 35 days, one would actually start with legal action. It also deals with legal fees, and we will also suggest that one changes your rules in respect of legal fees to not only recover legal fees on a party and party scale, but to recover legal fees on an attorney and client or attorney and own client scale. The reason why we suggest that is in respect of the budgeting. As I said earlier on, you need to budget for that, but also we find it patently unfair that paying owners are actually now liable for the payment of legal fees to collect from non-paying owners. And we believe that the rules need to be changed in body corporates to actually recover all that money from the debtor and not place that burden on paying owners. So we deal with that in our credit policy, and obviously we deal with it as if that was already done and that action has been taken. But we will, Zerlinda will have that discussion how that should be done to change that, and then it makes it easier for body corporates to debit that fee onto the account of the debtor and to recover it from the debtor, and removing that liability from the owners. Then something that we are also dealing with is the allocation of payments and legal costs. So in terms of the law, payments that are made by the owner is firstly allocated to the oldest debt and then towards the newer debt. So what happens is if you have started a legal action and you allocate the payment towards the older debt, the debtor can then just make a couple of payments and then still not caught up in respect of all the outstanding levies. And then that summons has been negated because the amount that was sued for has now been effectively been nullified, and as such a new summons has to be issued. So that then means that the body corporate will repay for the issuing of a summons. So the same process can happen over and over and over again. So we believe that one should also change that and make, once you have started legal action, you then make it possible that the payments be allocated first toward the newest debt. And in that way, you protect your summons and you then can go through the legal action without being hindered by a payment merely to stop you from continuing with the legal action. So we've dealt with that in the credit policy as well. And that is something that we suggest that body corporates must do, because that will also minimize the legal expense in that that there won't be several actions have to be instituted for the collection of the levies from a single debtor. Something which we believe is very important, especially in these times, are special payment arrangements. I mean, we've gone through COVID. We are aware that people have lost their jobs, they've lost their income, and people have fallen in arrears. So the other night, I've also said on a podcast that it's important that trustees actually make arrangements, and that debtors and owners go to trustees and say, this is my financial situation. I need to make a payment arrangement. I need to pay this off over a reasonable period of time. That arrangement must then have a portion that deals with the payment of the arrears over a reasonable period of time for about 6 months or so. But it also needs to deal with the current levy that needs to be paid. Otherwise, that debtor will just fall more and more in arrears, and at the end of the day, he won't be able to get out of the problem. So it also needs an acceleration clause. Now, an acceleration clause is a clause that once you have agreed to pay your debt over a certain period of time and you don't comply with that agreement, that the full amount becomes due and payable immediately again. Because you don't want to have a payment arrangement without an acceleration clause where a debtor has to pay over 12 months, and then on a monthly basis he doesn't pay, and only after month 12 can you actually issue a summons against him for the full amount. Where if you have the acceleration clause in the acknowledgement of debt, that will negate that, and you can immediately issue summons for the full amount if the debtor does not comply with that obligation to pay. We also think that there should be in the credit policy a procedure to list owners that are not paying on credit bureaus. So there are specific credit bureaus that are specifically targeting this industry and the rental industry, for example, TPN, where if a owner does not pay, that he then be recorded as a bad payer on their system. They then send out an SMS to the owner and says, you have now been reported to the credit bureau because you have not paid your levies. And that also will get them to understand that the non-payment of levies will have an effect on their credit worthiness and their ability to raise credit to buy a car or a bond and so forth. And that will then force them to actually make payments. Then something else that we've got in the credit policy, something that Graham Paddock is actually saying, is that one should make a provision for early settlement incentives. So get owners to pay up front. And if they do so for a whole year, then the body corporate does have cash flow for that whole year. They know that the money is in the bank, and you can give an incentive to those owners that can do so. Obviously, one will have to budget for that because if there's a certain percentage of owners that will pay up front and they will get a 5% or a 10% discount on their levies, by doing so, one will have to make provision for that in the budget, that you will have a smaller amount, and obviously that will have to be proportioned over all the owners. So I will also give this draft credit policy to you guys. We will make it available. So we'll send out the link where you can then link on that and get that. I'm going to ask for Zerlinda now to actually have a chat to us about changing of rules, and I'm giving over to you. Thanks, Zerlinda.
Thank you very much, Willie. Welcome, everybody. I hope that everyone can hear me and that the quality is good. I see my video hasn't switched over yet, but I'm sure that it will. Willie has raised such interesting points, and I've had quite a bit of experience with levy collections in my past, having been a candidate attorney at BBM Attorneys with Marina Constas, and actually working with levy collection matters and standing in court and having to, argue the body corporate's right, and matters getting thrown out because of the simplest thing not being adhered to. For example, a trustee resolution, or that a quorum or a notice period of an annual general meeting wasn't correct. And it's amazing how much work will go into an application like that simply for it to be thrown out so simply. Before the Sectional Title Schemes Management Act came about, we also dealt with a lot of arbitrations. And that was also very interesting to see how a levy collection matter, once dealt with in court, was referred to arbitration. Now, of course, with the Community Scheme Ombud Service Act and the Community Scheme Ombud Service, of course, applications can be made there. I would like to ask the participants this morning if they can just post in the Q&A or in the chat function whether or not they are aware of or have been involved in any applications that have been made to the Community Scheme Ombud Service for the recovery of levies. I'd be very interested to see, whether or not that service is being utilized. From my experience in speaking to people in the industry, 99.9% of the time matters are still dealt with in court and not through the Community Scheme Ombud Service. So that's something to think about while you're listening to us further. So the issue about amending the body corporates management rules is, of course, incredibly difficult, and we don't even want to think about having to go to the members to try to get a unanimous resolution. Not only is it incredibly difficult to get a unanimous resolution, being 100% vote of the people at a meeting or 100% of the vote of all owners, the quorum requirement for a meeting is exceptionally high. I was under the mistaken illusion that perhaps with COVID and remote attendance being such a big thing, that quorums at meetings would be a lot higher. And unfortunately, I've been quite disappointed to see that quorums really haven't changed. In fact, some of them have gotten even worse having meetings remotely. And that's also something I'd like you to comment on, your experience in arranging meetings or attending meetings in regards to quorum, and how often you haven't been able to pass a resolution because you haven't had a quorum, or how often you've had to adjourn a meeting because you haven't had a quorum. Now, obviously, with any type of amendment to your rules in regard to levies or legal fees or penalties, these need to be in the management rules. And the reason behind it is because the prescribed management rules actually deal with this matter to start off with. So we cannot have a conduct rule trying to change what the prescribed management rule says, which is why we have to unfortunately go for the amendment of management rules. So, like I said, to amend management rules, it requires a unanimous resolution. Remember that a unanimous resolution has to be taken either at a meeting where there is a quorum of 80%, alternatively in round robin, in writing, by 100% of the owners. Can you imagine in a large scheme trying to get 100% of the owners to agree to a resolution? It is next to impossible, if not impossible. And of course, if you don't get the quorum requirement the first time around, although the meeting can be adjourned to 1 week later, that 80% quorum doesn't fall away. You still have to get 80% quorum. Of course, you can attempt to get proxies. Proxy canvassing or proxy farming is still very much alive, even though it is limited to 2 proxies per person. It's also possible to amend your proxy form to allow for a power of substitution, to ensure that should a proxy holder not be able to attend, that proxy can be utilized elsewhere. Of course, if that does happen, there is a risk of broken telephone, and should you wish to ensure that your vote is actually made as per your instruction, to actually give a written instruction on that proxy form. So if you do get a unanimous resolution passed, just a reminder that that amended management rule would need to be submitted for review and approval by the Community Scheme Ombud Service. They will review it to ensure that it is not going to be in contravention of the Sectional Title Schemes Management Act, in contravention of the prescribed management rules, or not suitable to the scheme at all. Now, if you are not able to reach that unanimous resolution, then you can make an application directly to the Chief Ombud of the Community Scheme Ombud Service, pointing out that there was an unreasonable opposition to the motion, or perhaps it was just unachievable to obtain that quorum because of the composition of the scheme, the size of the scheme. And although that process is a shortcut process to an application for dispute resolution, there is still a little bit of red tape that needs to be followed in order to get that outcome at the end of the day. But it's not impossible to change the management rules. And of course, if you are going to be embarking on the project of amending your management rules, or your conduct rules for that matter, it is never our recommendation to go to the members with simply one change. It's really not going to be worth your time or your effort at all. And every single day that Nicole and myself look at rules that we amend on behalf of our clients, we find new things that could potentially be improved or amended upon. So it's always such a great idea to use the opportunity to put together a list of things that you would like to amend in your rules, and perhaps consult with your managing agent or consult with a specialist in order to actually put those amendments through at your meeting and really use that time worthwhile. Now, some of the things that you would need to look at in changing your management rules, and Willie did mention most of them, is something that I used to love as an attorney under the Sectional Titles Act, and that was that lovely Management Rule 31.5 that allowed for an automatic recovery of legal costs and any other charges that the body corporate had to incur in regard to the collection of arrear levies, alternatively ensuring compliance with the Act and the rules. It was such a lovely provision that the moment the body corporate needed assistance, they would go and instruct an attorney or a specialist, and they would recover the fees automatically from the owner. Now, if you don't have amended management rules and your management rules were simply the prescribed ones under the Sectional Titles Act and is now the prescribed ones under the Sectional Title Schemes Management Act, you can't do that. You need to get the owner's agreement. Can you imagine? That's also something I'd love for you to comment on, as to whether there's ever been a naughty owner in the scheme that has said, yes, please do recover those legal fees from me. I agree that you can do that. It hasn't happened in my experience, Philly. I don't know if it's happened in yours. The other thing is that you would need to get a court or an adjudication order in regard to the costs. And, Billy will be able to give you a bit of certainty as to what that cost recovery is, but it's not going to be 100% of the legal fees that you've incurred. I think he actually did mention it. So it would be a very good idea to use either the same wording of the Sectional Titles Act or something a little bit more suitable to your scheme to allow you as the trustees or the managing agent to automatically recover legal fees. Of course, the legal fees would need to be incurred for proper work that was done. You need to follow a due process. You can't simply just whack legal fees onto an owner's account and wait for them to dispute it. So that's a very good rule in the management rules to change. When it comes to penalties and fines, yes, you can have those in the conduct rules. There's a couple of requirements of the Community Scheme Ombud Service in this regard. It needs to be at the bottom of your conduct rules after all of the nitty-gritty rules. It needs to provide for a due process, for example, a warning, an opportunity to come and plead your case with the trustees, perhaps to submit evidence, to cross-examine any witnesses. You know, it can become quite comprehensive if it needs to be. And then, of course, the amount needs to be qualified as well. It needs to be reasonable, and there is a limitation as to the amount of fines and penalties that can be raised from body corporate to body corporate. Now, Willie was quite correct in saying that if you do have a fining or penalty rule, by all means, you can raise that directly onto the owner's levy account. If you do not have a rule allowing for the raising of penalties and fines, then unfortunately you can't. Then you would again need their agreement, alternatively a court or an adjudication order. I have read, as has Nicole, many good sets of rules, only to find that they do not allow for fines and penalties. And unfortunately, our legislation has always been known as toothless, which means there's really not much we can do as management to ensure compliance. And very often we have to resort to that draconian measure of raising fines and penalties. But as long as it is reasonable, it is applied equally, and it fits the crime, essentially, the csos will have absolutely no issue with it at all, and you can apply it and ensure compliance that way. The same would go for any penalties associated with levy collection. If there is any administrative charges that are billed, for example, by the managing agent, if they're a registered debt collector, to send out a final demand or a reminder to hand it over for collection. There's also something interesting now under the Sectional Title Schemes Management Act, that the body corporate, either via its managing agent or the trustees, are needing to do that first final demand, which you would normally hand over to an attorney to do. Very often the attorney still does the final demand on their side, but that is a step that the body corporate can undertake. I can only imagine that the weight behind an attorney's final demand is slightly stronger than one coming from the trustees or the managing agent, which is why attorneys still do that for their body corporates. Some of the other things that you can have a look at in regard to penalties in regards to arrear levy collection is something that was under the Sectional Titles Act, and interestingly was not brought over into the Sectional Title Schemes Management Act. And the reason for that was that the Sectional Title Schemes Management Act was drafted before these amendments were actually made to the Sectional Titles Act, and that was the disqualification to hold office as a trustee. So many of you will remember that under the Sectional Titles Act, you couldn't be nominated as or stand as a trustee if you're in arrears with your levy account and you were told to bring it up to date and you failed to do so. You also couldn't be a trustee if you were in breach of the rules and were told to comply and you failed to do so. That disqualification is not in the Sectional Title Schemes Management Act, which means that if you want to enforce it in your body corporates, you'd need to put it in your amended management rules. In my mind, it is not correct for a trustee or a chairperson to be in that position if they are owing the body corporates thousands and upon tens of thousands of rands. They would need to recuse themselves from many decisions in regard to the financial administration of the body corporates, as well as decisions as to hand owners over. And one can imagine the members are not going to be very happy to be told what to do by somebody that is equally as naughty as they are, alternatively more so. So that is definitely something to put into your management rules. Something else that we've always had in the Sectional Titles Act and still continue to have in the Sectional Title Schemes Management Act, but that can be amended, is disqualification or exclusion from a vote. One can even potentially look at excluding someone from attending or being represented at, or at least participating in a meeting. So we know when it comes to ordinary resolutions, if you are in arrears beyond a certain point of time and you have an adjudication order or a court order against you, you are not allowed to vote. But for special and unanimous resolutions, you can. So that's another management rule that one can definitely look at amending to take away from a member what we like to call in homeowners associations privileges of membership. And I know that this webinar is aimed towards sectional title schemes, but if any of you work with or involved in homeowners associations, you'll very often find in the memorandum of a corporation, alternatively in the constitution, there will be reference to a member in good standing or reference to the privileges of membership. And very often this is not defined, and other times it is, but basically that allows a homeowners association, when an owner is in arrears or is in breach of the constitution or the estate rules or the memorandum of incorporation, to actually disallow them from the benefits of membership or the items of membership that are given as a privilege to members in good standing. For example, access to common property facilities, the gym, if your HA has a gym, or the clubhouse, the swimming pool, to attend at meetings, to participate at meetings, to vote at meetings, to allow a proxy to be at a meeting. I've been to quite a few meetings where I've had to tell people, sorry, you can't enter the room because you're in arrears with your account, and actually had an owner throw money at me to ensure that they would be allowed to attend a meeting. So it definitely worked, that's for sure. There is also an argument that can be made that you can not allow access into the homeowners association, but you can make it a little bit more difficult in perhaps discontinuing or deactivating a member or a tenant's access control and let them sign into the estate as a visitor, which can be a little bit of an irritation, and that way encourage payment of their levy accounts. So there's quite a few things that you can do in terms of your management rules, and something that Willie picked up just before he ended was the issue of amounts of money being paid going to the old estate first. And that is something that I absolutely love in levy collection, because you'll very often find that an owner will pay their levy account but absolutely refuse to pay the fines and penalties, or refuse to pay the legal fees. And in their minds, they're every single month paying their levies and not paying the fines or the legal fees. But in actual fact, any payment that they're making is towards the oldest debt first. And that debt is not only the levy, but the fines and admin charges and legal fees as well, which means in essence, they have actually paid those fines and those legal fees that they're disputing, and they're actually further in arrears with their levies. So that's something very interesting to keep in mind. Another amendment to the management rules before I end off this particular section is what Willie said Prof. Paddock has motivated, and that is the early settlement of levies. Remember, the Sectional Title Schemes Management Act does allow for a discount in the event that levies are paid up front. Again, I'd be interested to hear how many of your schemes actually allow that. I've only ever dealt with one homeowners association that has allowed that, and they stopped it quite quickly because they found that it was actually negatively affecting their budget, and the positive, in other words, the number of people that were actually taking it up was so low that it didn't have such a big impact. So most of the schemes that I'm working with and I know do not actually allow a settlement discount. But of course, as times change and as people's circumstances change, that's most certainly something to look at. Another thing that can be put into the management rules is perhaps, as Willie said, the credit policy, but actually a directive to the trustees, or this is something that can be raised at an annual general meeting as to how the trustees must deal with arrear levy collection. Should they enter into any type of arrangement or not, or should they take a hard stance towards levy collection? So these are all things that can be amended in the management rules, and although it's very difficult to do, I'm sure that you've seen that there's definitely some value in taking on this massive project and actually seeing it through to the end. Thank you, Willie.
Thank you, Zerlinda. I can just say that to make these changes, one need to consult with somebody like TVDM to assist with that. So it's important that one gets people that know and understand the Act to actually make these changes. Like Zerlinda said, that one does it all at once and not piecemeal, because it is such a difficult threshold to reach, and make that changes then as a global change to the rules, to make sure that levies are paid and that the appropriate action is taken when levies are not paid. Zerlinda, just one other thing. I saw that there was a question regarding the difference between the management rules and the conduct rules. Maybe if you can just elaborate in respect of that.
Sure. So Conduct rules is just as they say, it deals with issues of conduct or behavior, whereas management rules deals with your administration and management issues. So if you have never taken a look at the prescribed conduct rules and the prescribed management rules, I suggest that you do, and you'll very quickly see the difference between the two. Firstly, from an administrative point of view, conduct rules only need a special resolution for the amendment, and that is 75%. When I say only, 75% still sounds like a heck of a lot, but it is 75% of a quorum. And if your scheme is more than or 4 or more sections, that quorum is 33.3%. So 75% of 33.3%, or alternatively, whoever is at the meeting, is a lot less than 100% of an 80% quorum. So it's a little bit easier to amend conduct rules than there are management rules. Now, interestingly, from the Community Scheme Ombud Service perspective, when they review and approve rules, they do not allow conduct issues to be in the management rules, and they do not allow management issues to be in the conduct rules. And in both instances, they do not allow provisions of the Act to be repeated in the conduct and the management rules. So they're very strict in ensuring that behavioral or conduct issues, day-to-day issues, are dealt with in the conduct rules. And then, of course, the management issues, the legalities, the administration, issues about levies, issues about election of trustees, holding of meetings, quorum, etc., are dealt with in the management rules. And very often our clients, when we review and amend conduct rules and management rules, they say to us, you know what, nobody ever reads the management rules. Let's just quickly slot into the conduct rules something about insurance, or slot into the conduct rules that levies are due and payable on the 7th of the month, otherwise they'll be handed over. And as much as we understand that people generally don't read documentation, unfortunately, they have to, and it's not up to us or up to the trustees or managing agent to repeat it in every single document. So levy issues, legal fees issues, handing over of levies, recovery of legal fees cannot be dealt with in the conduct rules. They have to be dealt with in the management rules. And that, in a nutshell, is probably the difference between the two.
Thanks, Zerlinda. Now, what one would do after an owner has defaulted, I'll deal with legal action, alternatives, and then outsourced alternatives, which will also be me and Zerlinda again speaking about it. Zerlinda will speak about the community schemes ombud services in respect of what you do with them once the owner has defaulted.
So this leads to what I asked earlier, and I haven't had a chance to have a look at the chat function. I'll do so now when Willie speaks again. And if you haven't commented, perhaps just comment now, is the number of matters that have been referred to the Community Scheme Ombud Service, alternatively, whether or not you still hand your levy collection matters over to court as opposed to the Community Scheme Ombud Service. In my experience, none of my clients have handed arrear levy collection matters over to the Community Scheme Ombud Service, and it's quite a pity, unfortunately, but I understand why not. It's because at the end of the day, they will either not get a cost order, alternatively, they will get a restricted cost order, maybe in the amount of about 5,000 Rand, and the body corporate, as Willie said, will obviously pay a lot more for that process. Many managing agents, probably most managing agents, as well as trustees, are not able, capable, or happy to use their own time and resources to deal with an application and still want to outsource it to an attorney. And legal representation is not allowed at the Community Scheme Ombud Service at adjudication unless both parties are represented or both parties agree, or the adjudicator believes that based on the nature of the matter, they actually need to have representation. So we're quite fortunate in that we're not practicing attorneys, which means we're consultants. And from that perspective, we do assist applicants and respondents at the Community Scheme Ombud Service from application to conciliation to adjudication throughout that process, and have quite a good understanding of how that works. And unfortunately, as much faith as I have in the Community Scheme Ombud Service, from a timeline perspective, it is quite challenging at most to deal with these types of applications, although I have found that it has allowed for a lot more engagement between the body corporate and the owners than court proceedings do. Generally speaking, in my experience, once the matter has been handed over to an attorney, the body corporate just doesn't speak to the owner, and the owner doesn't speak to the body corporate. And it's more of a threat than it is an opportunity to actually engage with one another, which is something good from the Community Schemes Ombud Service perspective. And I always tell my clients as well that before they hand over to an attorney, they need to engage. They need to, as Willie said, arrange a credit policy or an arrangement with the owners and be open to try to settle an arrear levy collection matter before proceeding, because it is such a comprehensive and at times costly project for them to undertake, especially body corporates that don't have, the strength and the support of a company such as Stratafin behind them, and they're all on their own. Now, to start off, right from the beginning as to what the Sectional Title Schemes Management Act says about referring a matter to the Community Schemes Ombud Service, the legislation, you would have noticed, doesn't use the word shall anymore. There's a lot of mays and wills and musts. And when it comes to dispute resolution, the Act says that a body corporate may refer a matter to the Community Schemes Ombud Service. Now, litigation attorneys have the interpretation that the may means you may go to the csos or you may go to court. Other attorneys say that you can either engage and not go through a dispute resolution process formally, but informally, or you may go to the Community Schemes Ombud Service. In other words, you can't go to court. And just by the sheer fact that so many matters are still being dealt with in court, I believe that the interpretation is that there's an option between the Community Schemes Ombud Service and court. Although there has been a recent case law from court where it says that a body corporate hasn't exhausted its internal remedies by going to csos first. So again, it's all up to time to see where and how we're going to be dealing with disputes either through court or the Community Scheme Ombud Service. It only requires a trustee resolution on the part of the body corporate to institute proceedings at the Community Schemes Ombud Service. And if the trustees or the managing agent are going to be assisting the body corporate with that application, there will only be the costs, perhaps if the managing agent charges for that value added service. And then of course the application fee for 50 Rand for conciliation and a further 100 Rand for adjudication. 9 times out of 10, an attorney is involved one way or another, either behind the scenes or up front. And then of course that cost element has to be provided for in the budget. And as Willie said, a lot of body corporates don't have a budget for legal fees. So that's always something to keep in mind. The process is relatively straightforward and simple. There is an application for dispute resolution that has to be completed. And of course, the relevant order needs to be set out. Either you're asking for the payment of an amount, or you're asking for the adjustment of the determination or the calculation of an amount, or you're asking for the attachment of rental. I found in practice when I was doing levy collection matters that it was actually quite useful to go the route of attachment of rental in investment properties. And that was a nice way of encouraging owners to make their payments simply because they were getting the rental out of it at the end of the day. Body corporates often feel, owners in body corporates often feel that it is more important when they draw out of the hat at the end of the month to pay their bills, that they would much rather pay their bonds than they would pay their levies, because a body corporate doesn't work as fast as a bank or has as much teeth as a bank does. And I think that is a misconception. A body corporate will work as fast as it needs to work and as fast as it is directed to work to recover levies, and the legal process will be exactly the same for a body corporate as it would be for a bank and a mortgage. In regard to the costs, I set out the 50 Rand and the 100 Rand. And of course, if the managing agent charges, which I do believe they should, it's not something the managing agent should or have to do to assist a body corporate or an HA in the dispute resolution process at the Community Schemes Ombud Service. And then of course, legal fees as well. From a timeline perspective, sometimes matters get dealt with relatively quickly, other times not. There was recently a poll that was conducted on the Sectional Title Living Group on the Facebook page that Willie and I were talking about right at the beginning. And it was very interesting to see the wide spectrum of timelines that people have experienced with the Community Scheme Ombud Service. And it all depends on the nature of the disputes and of course, how many delays are caused in between by either the parties asking for postponements or opportunities given to provide further information, or simply the unavailability of the conciliator or the adjudicator. We dealt with the issue of representation. And of course, although legal representation isn't allowed, there is ways and means around that, depending again on the nature of the disputes and the nature of the parties to the disputes. As I mentioned earlier, it's always vitally important for the body corporates or the homeowners association to have an internal dispute resolution policy that is really not regulated or doesn't have to be something too formal before they make the decision to hand over for collection, either through the community schemes ombud service or through court. And that internal dispute resolution policy, again, should be in the rules, in our opinion, both in terms of conduct rules and management rules. So that is the community schemes ombud service in a nutshell as to the process. When it comes to the conciliation being held, the adjudication being held, and an adjudication order being handed down, that adjudication order is valid and binding. It cannot be taken on review, and it can only be appealed on an error of law. In other words, the adjudicator made an error in applying the relevant legislation or the relevant law. And then, of course, should it be for the payment of monies, the csos would issue a certificate that the body corporate can take to either the magistrate's court or the high court, depending on the quantum of the amount that they have recovered, and then enforce it like they would enforce any other court order. So that's pretty much what I have to say about the csos, Willie.
Thank you, Zerlinda. Just one thing that I want to touch on, and you've mentioned it, is that the csos order is only appealable on law and not on fact. And we believe that that is a dangerous area at Stratafin. Because if an incorrect factual decision is made by these people at csos, then obviously you sit with a problem in that it's not appealable, where in a court of law it is appealable and you can take it to the next level. So that's one of the reasons why we from our side are not too keen to take matters through the csos process. And obviously also, once you've got the order at csos and you need to do an enforcement order and take it through the courts, you still have basically the same costs, because that is merely like a default judgment that was now granted. So that is just the start of the legal process. So there's various other steps that need to be followed thereafter, and to us, that saving is a very, very small saving in respect of going to csos rather than taking it through court. But dealing with the legal process, obviously one starts by calling or trying to make an arrangement with the owner, and that the trustees or the managing agent, if that's their mandate, should do. Then the letter of demand, as Zerlinda explained, which is now a requirement that needs to take place prior to the issuing of the summons. That will give an owner a 14-day period to then make payment, and if he's still then in default, then one can proceed to issue the summons or refer it to csos, depending on what process you want to follow. You can then have your default judgment or your enforcement order thereafter, and then the long process starts. So that is the process of attachment of movables, and the attachment of immovable property is the longer part of the process. So in terms of the South African law, one must first attach movables of a debtor before you can attach immovable property. Or you should get what is called in law a nulla bona, which is a certificate from the sheriff that there were not sufficient assets to cover the amount that was claimed in respect of the judgment, debt and costs. And then only one can proceed with the immovable property. But we can also not just attach immovable property. You need to get a court order that now allows the attachment of immovable property. That's in terms of Section 66 in the Magistrates Court Act, or Rule 46 in the High Court, that allow the attachment of immovable property. There are also various rules around that. One need to determine if it's a primary residence or secondary resident. One need to determine the age of the people and so forth. So depending on all these circumstances, the application changes. And we have found at Stratafin that we have great difficulty in getting orders for the attachment of immovable property through the magistrates' courts. So we mainly take our applications to attach immovable property to the High Court, and we've got a far better success rate in that respect. This whole process, where one attach the movables, then go to an application for attachment of immovable property, and eventually the sale and execution of the immovable property, can take anything from 12 months to 2 years. So it is a very long and tedious process and costly process that needs to be followed. So yeah, so just to come back, obviously then one needs to budget for that and make sure that you have the sort of sufficient resources to pay for that. I've seen some alternatives coming up. Zerlinda has also discussed some, the attachment of rental payments. Obviously, that is something very nice where there is a tenant in the property and you can attach that and utilize that in respect of the levies. That attachment can take place through csos, or it can take place through a High Court application. We now see orders for to the Supreme Court for discontinuing of services takes place, where the body corporate applies for the cut-off of electricity and the reduction of water, or, for example, curtailing access to the facilities, like Zerlinda also explained. So we see those applications now taking place. That also then forces owners to make payment. We have known in the past where body corporates just took the law into their own hands and just cut these services. Obviously, that causes a problem because that is spoliation, and the debtor can then go to court and get an order against the body corporate. So it's not something that you would want to do. Then the payment arrangements that we've discussed at length that body corporates should try and make, because that stops the bleeding in respect of legal fees. So that's an important thing that one can do. And then also, as I mentioned before, the listing of the debtors to the credit bureau, and making sure in that sense that they are aware that it has an effect on their credit rating. So these are all important measures that can be taken to make sure that body corporates recover their money. We then also are going to discuss the outsource alternatives, and in this regard, I want to discuss the Stratafin model, and I want to say that what Stratafin does is we purchase the outstanding levy books. So it is not a loan to a body corporate. It is not a loan that requires monthly payments by the paying owners in respect of rental. It is a purchase of that book, and we would then collect that book at our risk and at our cost, minimizing the risk and cost for the body corporate. So if there's any body corporates that would require services like that, obviously you can come get into contact with Stratafin, and we will give you an assessment of that levy book, and we will have a look at all the amounts that were raised on that levy book to make sure that they are compliant with the various rules. Then the other service that can be taken, and I'm going to give that to Zerlinda, and she can tell you about them and what service they can render for you guys.
Fantastic. So I think I've punted the management rule and conduct rule amendments enough, but that's definitely something that we do quite a lot of. I would like to say, and Nicole can kick me under the table if not, we probably get probably a new instruction to amend conduct rules or management rules at least every couple of days, which is incredibly exciting, because it means that the more schemes we work with, both homeowners associations and body corporates, the more these schemes are on the right path and the right direction to having updated rules, and rules that can actually work for them, as opposed to simply, a copy and paste the developer potentially did, or, rules that are so ancient that, most of the owners have moved into a retirement development that aren't actually hanging around in the scheme anymore. So that's definitely something that we work with. We also consult with owners and provide legal opinions and letters. We assist them in the process of making applications to the community schemes ombud service. And that is not only behind the scenes, but front and center as well, not being practicing attorneys. And Nicole and myself both have quite a lot of historical experience with the community schemes ombud service, having worked with paddocks right from the beginning of the inception of the community schemes ombud service and the legislation before it even came out. And then, of course, training of the community scheme ombud service staff in part as well, right in the beginning. So we have an intimate knowledge of how that works. And then other than that, of course, attending meetings, potentially attending or chairing a disciplinary committee meeting that might happen in terms of your rules to deal with an arrear levy collection matter, or to deal with fines and penalties that have have been raised. Interpretation of your rules as well. Sending threatening lawyers' letters is something we do as well. We're not too fond of it, not being litigation attorneys, but we do that if necessary. And then, of course, offering the service of professional trustee. And that is very often a very good thing to have, where you need that additional backup and support in regard to guidance and advice as to what is best for your scheme. So from an overall community schemes perspective, we offer quite a lot of services. And then, of course, in regard to the particular matter at hand, the levy collection matter, it is everything from trying to mediate and negotiate a settlement, being involved in the process of internal dispute resolution, and then, of course, the applications to the community scheme ombud service as well.
Thanks, Zerlinda. Do you want to have a look at the chats? I mean, you've encouraged people to give you some information, and then we can just have a look at a couple of those. If we're not going to get to all the questions, what we will do is we will send that to Zerlinda as well and to myself, and we will then endeavor to answer you guys within a reasonable period of time. And then obviously we will also send out the link to the freebies that we promised. So that you guys can have a look at that and see if that's something that will help you in your schemes.
Fantastic. So quite a few people have posted that they have made use of the community scheme ombud service, Lily, and I see you've got an amazing success rate with the community schemes ombud service in regard to arrear levy collection matters and the attachment of rentals, which is fantastic. A lot of you have also said that you still use the collection attorney through that process. I'm not too sure if that is through the csos or through court. Willie, there's something that you and I have spoken about quite a bit, and that is Shirley's question about, does prescription apply to levies? And if so, is it 3 years? And if so, from what point? I know that I'm always interested in that topic. I don't know if that's something you're wanting to chat about now.
I can quickly have a chat about that. I mean, obviously, there are different points of view. My point of view is that sectional title debt does not prescribe. And to that end, I normally refer to Section 3 of the Prescription Act that says as long as you are a member of the governing body of a juristic person, prescription will not run and prescription will be suspended. You can only unbecome a member once you have sold your unit, and as such, prescription is thus suspended until you unbecome, and you can only unbecome when you sell your unit and you've paid the clearance figures and transfer then takes place. So there are different opinions in that regard as well. I have shared on the Facebook group the other day a decision, and I think it's Reddy versus Green. Let me just see if I can find it somewhere here on my desk. Doesn't look as if I've got it, but in any event, I can also make that available. That is a decision of the High Court Natal Provincial Division, and in that decision, it's already Greenwood Village. Thanks, Josh. So in that decision, it was found that prescription does not apply. So I think that there are an argument to state that prescription is not applicable. I can say that surely from our side, we don't see courts raise prescription from their side. And as such, if we issue summons, and we issue summons over very long periods of time, sometimes back to 1994, we have never dealt with a prescription matter, and it's never become an issue unless it is being claimed by a debtor. And obviously, from our point of view, we will move that matter, if needs be, to the appellate division to make sure that prescription does not become an issue, because at the end of the day, one wants to secure the funds of the body corporate as far as possible.
That's very interesting. Shirley asked another question about the quorum requirements for unanimous resolution and a special resolution. So I didn't touch on it for a special resolution for conduct rules, but Shirley, if you are proposing conduct rule amendments and you don't get your quorum the first time around, you can adjourn it for 1 week later. And then, of course, after 30 minutes again, whoever is there forms the quorum, and conduct rules can get passed on that basis. Bearing in mind that if you get less than 50% quorum, which you'll likely do in that instance, you would need to wait for 7 days, almost like a cooling off period before you can submit the rules to the csos for review and approval, bearing in mind that rules have to be submitted within 10 days of the resolution being passed. But a unanimous resolution, if you don't have 80% quorum, that's not going to happen at all. But I don't know if you want to touch on one or two more questions. There is mostly comments.
I'm just quickly, I'm quickly going through them and see if there's anything that I can see. I think we've dealt with most of these things. So if there are any other questions that we haven't answered, we will definitely go through them after the webinar. I see that we've already exceeded an hour, and I see that we are starting to have a drop-off. So guys, we don't want to take too much more of your time, but we want to thank you all for listening. We hope that we shared some information that is useful to you guys, and if you need any assistance, we will send Zerlinda and my email details to you guys, and you're more than welcome to pop us an email, and we will then reply to you guys.
Fantastic. Willie, to you and Daniela and Stratafin, thank you so much for doing this, the arrangements, and for the opportunity to speak. I've really enjoyed it, and it's such an important topic today more than ever. So thank you very much.
Thank you guys. We
Zerlinda.
really appreciate it.